Hi, Bill Henshaw here again, Constitutional Kook Headquarters, more on the way to news and recent events. And this would include some of my personal work that I've just got finished updating my redress of grievance process. And this is somewhat of a novel thing that I have developed based on my 5 decades of intense, passionate, and independent study of the Constitution, history, and laws of the United States. The reasoning is that if the Constitution remains in existence and we have states admitted into disunion, we have to have remedies, judicial remedies, where we can get before a trial by jury if necessary, with the jury that can rule on the facts and the law. And this is not only true for the sovereign body politic of the nation and republic, which is one way or the other, for better or worse, free, white, male, and 21. Get used to it, unless or until the Constitution gets amended in conformance with that document and not in contravention of it. The good news is, with that change and we get back there, now Africans and Asians all of a sudden are going to have enforceable rights, including the right to trial by jury. I mean, this is so much better than what it has been for the last 160 years. You can't stand it. And this is where we want to be. And we can get there. And the best news of all is with what I'm developing with Redress of Grievance. The problem we have with those bastards, especially state bar association attorneys and black robe bastards, is that they don't think they have to do anything. They think we have no rights. Whatever errors or admissions they make, they have at least qualified, if not outright judicial immunity. They don't care and they don't think they have to. And yet these are public servants sworn to be bound by this Constitution and the laws enacted in pursuance thereof. And you see the difference here? Where did all of this change? And like any good quote unquote attorney, you don't ask questions you can't answer. And I have a lot of answers. To get some of those and information on my modestly priced constitutional defense document packets, send me an email, unincourt@gmail.com. That said, what I've developed here, the opening shot is going to be a letter following whatever goes on with your case. And we go right to the people that did it. And accompanying that letter is going to be a third party collateral petition for redress of grievance. And this is not a direct challenge. The good news is this is a collateral attack. And it's what you might say you could call previews of coming attractions, because the perps are already going to see that we know how to do the next step. And if they have any smarts at all, they're going to be able to figure out that we're going to know how to file a complaint if we have to do it. They may not know in what court that's going to be, and that could be a hell of a shock. But even if it's a 42 USC 1983, what looks like a civil rights complaint, that's not what it'll be. You'll learn more about that. Send me an email, uwinnincourt@gmail.com, and I'll get you information on all of my packets and what I do. So it won't be that way. Even if it is, I'm good enough to beat the bastards in their own corrupt court and their own bullshit statute. It's the way it has to be. We have to have a remedy. I believe I know where it is, which is not anywhere close to any of their courts, and for very good reasons. And you'll learn more about that. Send me an email, uwinnincourt@gmail.com. I'll explain all of it to you. But we can do it. And you got anybody on the other side that has half a brain, and there aren't too many of them, they're going to recognize, and especially with all of this relevant, admissible evidence that's in this document, and it hardly breaks the surface of what we're going to have. In other words, what we're saying to them is we have to get into a civil rights BS code. We're going to be, a heavy favorite to defeat your usually reliable summary ex parte 12B6 motion to dismiss. 95% plus of those cases end up in the circular file on the first motion. Not only will that not happen here, we are now going to be the ones rolling the loaded dice. Exactly what the original intent of the framers was, to keep government within the bounds of the Constitution. And I can't see any problem with that. All you advocates of civil rights out there, any of you that want to take me on in an acapella debate, go for it. I'm available with notice to do it anytime and with very little notice, by the way. Maybe with a Zoom thing like this, who knows, in person if possible. And I would love to do that in front of a jury. If I get in front of a jury with my acapella knowledge of 230 years of American law and history, it won't be funny for the other side because they can't stop me. I'm an expert witness and I can prove it, which I did in Columbia, South Carolina, when I wrote an 18-page hand-printed, non-statutory federal writ of habeas corpus with 40 case citations and no errors. They probably haven't seen anything like that in Washington, D.C. in 150 years. Now, I didn't officially get heard there, to be sure, but you know damn well they got a call in Columbia, get him the hell out of there. We can't answer these questions on the record, or at least that's what they said 5 years ago. God, I can't believe it's been 5 years. Now they may actually have our backs, and the difference is that this petition might have been heard if I were in that jail cell today. So that part we will see about. But I think when last term they cited the case called Cohen's v. Virginia, and that's the best decision ever made. And people say, "Oh, that's old law. They don't use that anymore." Ain't 200 years, but they cited it twice last term in key cases with Texas v. California and Texas and the quote unquote election case of 2020. And you can't cite that case without knowing exactly what it means. Now, to be sure, these citations look like two justice dissents with Alito and Thomas, but a hell of a lot more is going on there. I'm sure they told the 3 Trump appointees, stand down, wrong time. We'll wait and see what develops. Maybe they get back from summer vacation and we'll see more of what I'm expecting to be there. And if so, I'm going to be one of the first in line and say, hey, guys, it's about time you do your job the first time in 160 years here. This is mostly your fault. And the conservatives on the court, I think, know it very well. We'll see if they're ready to do something about it at long last. If that's the case, we have a real shot at it here, especially with this mandatory COVID vaccination BS that's going on out there. Video for another day. But that said, the news is all good here. It just gets better and better seemingly every week. And if we can shortcut this redress process, and I thought even before what I've just developed here, we're not going to have to file any court papers because they'd have to be crazy to want that to happen. And now it becomes public. And a quickie on that, by the way, I just was helping my sweetie in the case of a probate case. It's kind of a long story, but they never got heard in the probate court. And now they're in jeopardy of being evicted from the house. And we don't even know who the landlord is. We don't know who owns it. We don't know if the probate court had jurisdiction. We don't know if California is a state. So I just filed one of these non-statutory federal writs in the U.S. District Court for San Francisco. And it got a case number. It got filed because I sent a 12-page love letter to the presiding judge, and you can get that, when you send for information on my document packets. And I said, this is what you have to do. This is your sworn duty. You file the documents, no forms, no filing fees, nothing. Got filed. Interestingly enough, the court where it's scheduled to be heard is Eureka. For those of you who don't know, that's 300 miles north on the Oregon border with a hell of a lot less media coverage because this gets filed in San Francisco. Oh, who knows what might happen, but that's where it should be. I mean, think about that. 300 miles we have to go for a hearing and no way to get there. So in my follow-up letter to Chief Justice John Roberts and some other official actors, I said, in effect, if you want to get less publicity, why don't you get more bang for the buck and have it sit up to the district court in Point Barrow, Alaska, the northernmost point in the entire United States, and they got virtually nothing there in the way of media, so it'd be quite safe there. In the next paragraph, I said, why don't you go to tell the truth about it and have it sent to the district court in Pyongyang, North Korea. We have the same damn democratic government we have there. The only difference is they have a much better turnout in the elections there. The last election was 99% or so. Are you listening, Maricopa, Arizona? I mean, that's exactly what a good democratic government wants to see, a high turnout, and it makes it look like everybody's in the mix. They have a say in things, and it's exactly the opposite. And as you'll learn by acquiring my modestly priced materials, I can prove no electorate, no elections, no states, no 14th Amendment. And it goes on and on. And you start raising these issues instead of these BS civil rights crap things that get done all the time. Al Sharpton and Jesse Jackson. Get rid of this nonsense. We all have to work together. Americans, Africans, Asians, cut this BS divide and conquer they've been doing for at least 150 years and get to the real issues. And we'll have a much better shot at it in the only nation ever ordained and established in which I think progress like this can actually happen. If it does, then we set the stage for the whole rest of the world to follow what we're doing. And that's what we should be doing, is it not? Leading the pack. That's the whole idea of the framers of the Constitution. So it's exciting times, and it will be for you. We can get a lot done here. And with comparatively little efforts. You're going to have work cut out for you, though. Like Franklin once said, eternal vigilance is the price of liberty. So studying my documents will be part and parcel. But at the same time, when you get those, you also get a lot of backup from me, including as much TLC via email as time and circumstances permit, complimentary phone consultations, and even a complimentary Zoom appearance at a contested hearing. I'll have your backs. There's a hell of a lot more you can say for any of these state bar association attorneys. Ain't. That said, remember to like the videos, tell your friends, subscribe, get the word out. The sooner we start moving in the right direction here, the quicker we get these bastards off our backs. Thank you.